Welcome back, everyone. We are going to finish up with the steps in the criminal justice system. So we're still in chapter 12, and we're going to finish up with the last part of the system. So hopefully you printed out the chart that I was referring to in the last lecture, and we're going to just finish up and keep going through it. It was just so long to do it all in one, so I just wanted to break it down into two. Okay, so when we left off, we were talking about the arraignment. So now what we're going to do is talk about what happens after that. So we are going to move into what we would call the pre-trial stages. So after the arraignment, do you go straight to trial? And the answer is no. You have what's called pre-trial discovery. So pre-trial discovery is the idea that this prosecutor the defense has to ask and the prosecutor has to give information over to the defense, okay? So discovery is considered the formal process of exchanging information between parties about the witnesses and evidence they'll present at trial. Now, generally, the way discovery works is the prosecution has to give most what they have to the defense, because we don't really have surprises at trials. We really have all that information exchanged for the sake of fairness. We want both sides, or we want the defense to have access to that and to be able to prepare for trial, knowing what evidence the defense has. So that's what occurs during the discovery. There's a couple defenses that if the defendant raises, they have to send information over. So like if they're raising self-defense or alibi or insanity, they may have to send some of their information over to the prosecutor for those defenses. But for the most part, it's the prosecutor providing information to the defense. Now, what information does the prosecutor have to turn over? This has been the focus of a lot of litigation. And this is the main discovery court case. It's called Brady versus Maryland. And what the Supreme Court says is that the prosecution has to turn anything over that's either exculpatory or inculpatory evidence, directly or indirectly relating to innocence. So exculpatory is evidence that tends to show that the defendant didn't do it. So you have to send that information. And you also have to send information over that could show that they did, inculpatory evidence, and either directly or indirectly relating to the case. So it really covers a large spectrum of things. They have to actually turn over quite a few things. Now, the question is, what if there is just some extra evidence that doesn't really prove innocence or guilt? Does the prosecutor still have to turn that over? So when the prosecutor is evaluating what they have, what if they say, well, we just think this is peripheral, it's not really part of the case? Then the Supreme Court says, well, if the defense asks for it, you have to turn it over. We're not going to really let it completely be the prosecutor's discretion to determine if it's relevant to the case or not. So basically, if the defense asks for it and the prosecutor has it in its possession, then they have to turn it over. So when you're a defense attorney, that means you want to make your requests for discovery very broad and general so that you can get as much information as you can from the prosecutor, because they are required to turn it over. Now, does the defendant have to turn anything over? We said a couple different things they may have to turn over. So if they're raising an alibi defense, they have to turn over evidence of the alibi. If they're going to raise insanity, they have to notify the prosecutor that they're going to claim insanity. If they're claiming self-defense, they have to notify the prosecution that they're going to claim self-defense. So there's a few things the defense has to give to the prosecutor, but not very much. They don't have to disclose everything, but the prosecutor does. Now, in New York, we call this Rosario material, okay? And Rosario material includes any statements of witnesses who will testify at trial, okay? So if police have interrogated or questioned a witness, I guess it's more interviewed a witness, they have to turn over any police forms that they filled out, any signed statements that the witness signed, any paperwork prepared by the police. So it could be their memos or their notes or any information that they take down during that interview. all prior recorded statements. So anything directly related to that interview has to be turned over to the defense before opening statements. So New York is pretty vast in what it requires the prosecutor to actually turn over. New York also requires giglio material to be turned over. That's any information from the prosecutor concerning agreements with potential witnesses. So if you offer a witness, oh, we'll get you a shorter sentence, or we won't prosecute you, or we give you some plea agreement if you testify against this other person, all of that information has to be turned over to the defense. The defense has to know what you offered the witness for their testimony if you offered them anything. So that's called giglio material in New York. New York has also set down very strict timelines for discovery, and this is really new. This came out right before COVID. What the New York law is trying to do is get the information to the defense a little quicker. It used to have to be right before trial, and sometimes it was considered unfair because a prosecutor would offer a defense attorney, the defendant, a plea and say, well, we're going to prosecute you for this if you don't plead guilty to this. And the defense wouldn't really know what evidence that they had, and they wouldn't know how strong of a case it is. And so New York wanted to level that playing field a little bit more. So New York requires now that all discovery from the prosecution must be given to the defense 20 days after arraignment if the defendant is in custody, or a misdemeanor, or a felony. Okay, so if you are charging for a misdemeanor or felony, they have to get it 20 days after the arraignment. Okay. 35 days after arraignment if the arrestee is released in a misdemeanor or felony case. So depending on if the person's being held prior to trial, if they are being held in jail, then the discovery has to get over to them within 20 days. If they're released, then you get extra days, you get 35 days. But all that information has to be brought over or given over, handed over to the defense prior to these days. Now, what happens if prosecutors withhold Brady material? What if they don't turn over something they're supposed to turn over? Does it automatically mean a new trial, or does it automatically mean an acquittal and you can't find the defendant guilty? The Supreme Court has said, no, it's not automatic, but it is a case-by-case determination. So if the courts determine that the evidence withheld by the prosecutor is material to the case and would have made a difference in the case, then they're going to either order a new trial or they're going to completely let the person go for the Brady violations. So it's pretty harsh, and they've been really, really coming down on prosecutors for properly turning over evidence. So there's been a lot of cold cases or wrongful conviction cases where attorneys have gone back and got the folders years and years later, and they found evidence in the prosecutor's folder that was never turned over to the defense. And that's a really, really good way to ask for a new trial for your client if prosecutor failed to turn over that evidence. Now, can prosecutors use prior convictions to show that the defendant committed this crime? So let's say the defendant has a prior record. Can the prosecutor bring up that prior crime, that prior record at the trial to try to persuade the jury that they should find him guilty in this case because he's done it again in the past? And generally that's not allowed. It's considered prejudicial. The jury is supposed to be determining the case on the facts of this case, not on prior information. Now, if the defendant takes the stand and says, oh, I've never committed a crime, then they can bring it up to show that you're lying. But in general, they can't do that. And that is called People versus Sandoval. And so if you're the defense and you think the prosecutor is going to use your client's previous criminal record against them in this case, then you ask for a Sandoval hearing and you ask the judge to keep that evidence out. Okay. So what do you do when you want to exclude evidence from trial? What is the name of the procedure called for that? Sorry, I forgot to take this out. That's for in class. So we have talked about the exclusionary rule and what happens when the police do something that's unconstitutional. We've said that the exclusionary rule says you cannot use that evidence in court. So we have to think about, when does that happen? The police aren't going to say, oh, I did it wrong, I'm just not going to use the evidence. The defense has to actually make a motion and ask the judge to throw that evidence out. And that's what we call pretrial motions. So pretrial motions are when either side asks the judge to make a determination on something prior to the start of the trial. We want them to make some big decisions about what evidence can be presented at the trial before the jury's there. And those are what we call pretrial motions. Now, there are different pretrial motions. So the first question is, what is a motion? I'm saying motions. What does motion mean? A motion is just a written or oral request that the court make a decision about something prior to trial. So you don't want the other side to say something to the jury ever if there's certain evidence you want to keep out. So we need the judge to make the determination about the evidence and what evidence is accepted prior to the jury being there. So that's what all happens. So when we want judges to make those decisions, we ask the judge to decide a motion. So we make a motion. We request the judge make a decision. Now, what are the pretrial motions? There are lots of choices, and we're not going to go through every single possibility, but we're going to talk about certain ones. Okay, so the first one we're going to talk about is the motion to dismiss. Sometimes the defense looks at all of the discovery and all of the information provided by the prosecution and thinks, there's no way they're going to convict my client. They cannot prove each of the elements of the crime beyond a reasonable doubt. So the defense will make what's called a motion to dismiss. And what you're doing is you're saying, judge, they don't have enough evidence. We need to stop this now. No trial, just dismiss the charges against my client. And that's what we call a motion to dismiss. Sometimes you see motions to dismiss also with double jeopardy claims. So if you want to claim that your client was already tried for these crimes, then you make a motion to dismiss on double jeopardy claims. Now, when a motion is made to a judge, the judge has two choices. They can dismiss without prejudice. That means that the prosecution can bring the case back later if they find more evidence, or you can ask for a dismissal with prejudice. A dismissal with prejudice means the case is over forever. The prosecution can never bring this case back to court again. So obviously the defense is always going to make a motion to dismiss with prejudice, because they want the case to be over. But a lot of times what happens is the judge will dismiss without prejudice, and then it allows the prosecution to go back and fix the mistakes and bring the case again. Now, another motion that they could make is what we call a motion for speedy trial. So remember, it's right in our Sixth Amendment. We have a right to a speedy trial and public trial, okay? Why? Why do we need speedy trials? Well, multiple reasons. We don't want people sitting in jail for extended periods of time. And also the evidence can get stale or lost or misplaced, or people could forget. So we want the trials to move forward at as fast as we possibly can, so everything is fresh. So Congress has passed what we call the Speedy Trial Act. So the Supreme Court has said basically speedy trial means no undue delay. So you have to try to move as fast as possible. But Congress said, you know what, that's not really good enough. We're going to give specific time periods when things have to occur. So what the the federal law says, that you have to start the prosecution within 30 days of arrest. So once a person is arrested, If you haven't gotten a grand jury indictment already, you only have 30 days to get it. Okay. So a lot of times they get the grand jury indictment before they even make the arrest. But if you make an arrest prior to having the indictment, you only have 30 days to convince the grand jury to indict. Now, if there's no grand jury in session within those 30 days, they'll give you an extra 30 days. You get 60 days. But you can't just sit in jail under arrest without the formal charges. So you only have 30 days to get those formal charges. Now, after the arraignment, after the indictment or information, you have to be arraigned within 10 days. So if you get an indictment or the prosecutor completes the prosecutorial information, that person needs to be brought back in front of the judge within 10 days of the indictment or information and be arraigned. So again, we can't have this long delay between the formal charges and the arraignment. You only get 10 days to do the arraignment. And then what the law says is after the arraignment, 60 days before the trial has to start. So the prosecution has to be ready to start the trial within 60 days of the arraignment. Okay. So that is the rules. Now you might say, well, I know some trials that take a really long time. They're not done in 2 months. Well, remember, this is the defendant's right. The defendant has the right to a speedy trial. But if the defendant needs more time, the defendant can ask the court for more time. And so that's why sometimes it takes a while. Because if you think about it, prosecution isn't going to move forward until it has all its evidence. So they could be investigating this for months, weeks, years. And then once you give it all to the prosecutor, the defense may not be instantly ready. So a lot of times the defense asks for more time to get their case ready. Okay. Now, another motion that can be made is a motion to determine competency. So we have talked about insanity. And we said, if a person's insane, you can't find them guilty. And we quickly mentioned this idea of competency. Remember, we cannot force a defendant to stand trial if they are not mentally able to at the time of the trial. So you could be insane or not insane when the crime is committed. But once the trial is supposed to start, we have to make sure that you're competent at that moment. If the defendant does not believe that their client is competent, they may have a motion to determine competency, and the judge will have to assess, does the defendant have rational and factual understanding of the proceedings? So do they understand what's going on? And can they help or their attorney prepare for the case? If the judge determines these two things do not exist, then what happens is they send the person to a mental hospital until they're competent, and then they host the trial. So this doesn't postpone it forever. It just postpones it until the doctors determine that the defendant is in fact now competent. And at that point, the trial then would proceed. Now, another motion that could be made is what we call a motion to change venues. So sometimes the trial is set to occur in a place where there's lots and lots of publicity. So it's going to be very, very, very difficult to find a fair and impartial jury. So the defense sometimes can make a motion to move the trial to a different location. So first you have to decide where is the trial supposed to occur. And it generally occurs where the crime was committed, in the jurisdiction where the crime's committed. And then you have to ask yourselves, is it possible to give this person a fair trial in this jurisdiction? So like when the Oklahoma City federal building was bombed and lots of kids and people were killed, they wanted to hold the trial in Oklahoma City. And the defense said, no, there's no way. Everybody knew somebody that was involved that was hurt or injured. So they asked for a change of venue, and then they moved it to Colorado. So the idea was there's a better chance of getting a fair and impartial jury if it's in a different venue from where it occurred. So I'm going to skip that. You can read it later. Now, I want to talk about the last types of motions And these are all going to deal with the exclusionary rule. So I just want a quick review. What is the exclusionary rule? The exclusionary rule is the rule that says if evidence is obtained illegally, it can't be used against the defendant at trial. So then when is that determined? When do we exclude the evidence? How does that occur? Well, that occurs prior to trial, and the defendant makes a motion asking for the evidence to be excluded. These are what we call pre-trial suppression motions. So suppress means the same thing as exclude. So if the defendant looks through all the discovery provided by the prosecution and decides that a piece of the evidence was wrongfully obtained, that their constitutional rights were violated in obtaining that information, then the defense asks the court to suppress or exclude that evidence in these pretrial suppression motions. Now, the thing with these motions is that their names and the motion you add or you request is dependent on the evidence you're asking to be suppressed. So basically what you're saying to the judge is this is this kind of evidence, and I want a hearing for you to determine if it should be excluded. So I make a motion asking for a hearing on the issue, and then the judge will listen to both sides and make a decision. Now, these motions, I said, were based on the type of evidence and how it was obtained. So if it's dealing with arrests, it's a special motion. If it's dealing with pretrial identifications, it's another name of a motion. So the names of the motions are directed towards the type of evidence you're asking to be suppressed. So if you are saying that there was a bad interrogation, there were Miranda violations. So if you want statements made by the accused, the defendant, to be excluded or suppressed from trial because their Fifth and Sixth Miranda rights were violated, then you would ask in the federal system for a Huntley hearing. In New York, we call it a ventimiglia hearing. It's the same thing. We just have a different name. So if your argument is that there was a bad interrogation and you want those statements to be kept out of court, then you request a Huntley hearing in the federal system or a ventimiglia. And so you say, Judge, these are the reasons why we think it was bad. Let's have a little hearing. You can talk to the the police officers and the defendant, and you can see whether or not this evidence should be excluded from trial. Now, we already talked about this one. If you think the prosecutor is going to use your client's previous criminal record, then you ask for a Sandoval hearing, and the judge will have to make a determination of whether or not the prosecutor is allowed to talk about your prior criminal record. And in most cases, it's not, because they're going to say it's too prejudicial to the defendant. If you think that there was an illegal search and seizure, so this goes to search and seizure. If you think the police, when you go through the whole analysis of the search and seizure flow chart, and you think that the police somehow violated search and seizure Fourth Amendment rights, then you ask for a MAP hearing, meaning you think the evidence obtained during that illegal search and seizure should be excluded or suppressed from trial. So MAP hearing is search and seizure. If you think it was a bad arrest, if you think that the police did not have probable cause to arrest, and you want the judge to exclude all evidence obtained during the arrest and after, then you ask for a Dunaway hearing. So a Dunaway hearing is claiming bad arrest. If you are saying the pretrial identification procedures were bad, then you're going to ask for a Wade hearing. So if you think if there was a substantial likelihood of misidentification or the procedures were suggestive and unreliable, then you're going to ask the judge to keep it out, and you're going to ask for a Wade hearing. If you want scientific forensic evidence to be admitted, and we have to determine, or if you don't want the other side's forensic evidence to be admitted because you think it's faulty, then you ask for a Fry hearing. So the judge will make a determination on that evidence prior to trial. Now, lots of motions, and you may have multiple to make. You may think that there's multiple mistakes throughout the process. You can combine as many hearings as you want into one motion, and we call it an omnibus motion. So an omnibus motion is one motion that includes all the pieces that you want. So you could say, A, I think the interrogation was bad, exclude that. B, I think the pretrial identification was bad, exclude that. C, I think the search and seizure was bad, exclude that. So you would include each of your motions under one large motion called your omnibus motion. Okay, so let's challenge your knowledge. Karen's arrested for DWI. Prior to the trial, prosecutor informs defense attorney that she will use Karen's prior arrest record, which contained 2 prior public drunkenness convictions. What motion can she make to keep this information out of the hearing of the jury? So prior conviction, which motion? Sandoval hearing. Okay. Now, Bobby is arrested and taken to the police station. During her interrogation, she confesses after 12 hours of questioning without an attorney. During that time, she was not offered food or beverages. What motion could her attorney make during the pre-trial process? Okay, so bad interrogation. Which motion do we ask to suppress evidence from a bad interrogation? That's our Huntley hearing in the federal system, or Ventimiglia in New York. Jackie's driving home from a party. She drives the speed limit. There's no reason to pull her over, but the officer approaches her. She realizes it's her ex-boyfriend, who she just broke up with last week. He orders her out of the car, searches the car, and finds an empty beer bottle under the car seat. He arrests her for open container. What motion could her attorney make in the pre-trial process? So, bad stop, question, frisk, arrest. So we have a bad arrest, no probable cause to stop in the first place. What motion do we make? Dunaway. Okay, so that's a Dunaway hearing, or MAP hearing then for the search. So they found the bottle. You can say first the stop was bad, and then the search was bad because there was no reason to stop them in the first place. So you're going to argue both, and the second would be bad search, MAP hearing. You are contacted by a client who wishes you to represent them in a murder trial. Your client informs you that he was placed in a pre-trial lineup. Your client is 6 foot tall, blonde, thin, white male, and he was placed in a lineup with 3 men with black hair, 2 men that weighed over 300 pounds, and an African American. What motion should you make in this pre-trial procedure? Bad pre-trial identification. Want to keep it out. That's our Wade hearing. Okay. You're at a restaurant with friends and a drink and a glass of wine at your dinner. After dinner, you exit the restaurant, approach your car. You get into your car. The police approach you, open the door, pull you out, and handcuff you. He tells you that he is arresting you for DWI because he saw you drink wine in the restaurant. You admit you had 1 glass. You inform your attorney that there's no probable cause to arrest you because you were not intoxicated. What motion should you make to suppress the statement that you drank 1 glass? So we're going to say bad arrest, and then we're going to say bad statement. So the statement is Dunaway hearing. You've been arrested for murdering your ex-boyfriend. The police say that the scent of your perfume still remains in the room when they arrived. The prosecutor wants to have an expert testify that the scent evidence was in fact in the room and that it matches your perfume. What motion could you make to suppress the scientist from testifying about this evidence? That's your Fry hearing. Okay, so those are the different motions that you're going to make. Now we're going to use those motions for your final project for this class. And I will talk about that when I'll give you a little video explaining the project. Now, do all cases go all the way to trial? So let's say we make all these motions, we've done all this stuff. Do all cases actually go to trial? No. During any of these stages, you can have plea bargaining. So I stuck it up here, but really a plea bargain could occur at any stage in the whole process. And remember, a plea bargain is a negotiation between the prosecutor and the defense. And they can either reach an agreement on what the charges are going to be or what the defendant is willing to plead guilty to, or the prosecutor could say that they would recommend a lower sentence. So they negotiate the charges and then they negotiate the possible sentence. So I'm going to skip that. You can read through it if you want. Now, let's talk about the trial and post-trial stages. We're going to go through the trial very quickly because we're going to spend a whole lecture just talking about the trial. So what is it called when a judge or jury formally examines the evidence to determine if a person is guilty? That's your actual trial. So the trial is when the jury or judge listen to all the evidence presented and make a determination guilty or not guilty. Now, remember that the defendant has the choice. Do they want the judge to make that decision? That's a bench trial. Or do they want a jury to make that determination? That would be a jury trial. It's up to the defendant to choose which one they want, okay? So if they want a judge to make it, they ask for a bench trial, or if they want the jury, it's the jury trial. It's our constitutional right to have a jury trial, so the defendant can waive that right if they want and just have a bench trial. Now, once the trial is complete, these are the choices that can happen. The jury or judge could say guilty, so they convict the defendant and find the defendant guilty. They can find the defendant not guilty. This is called an acquittal. So you could acquit the person. A hung jury is when the jury cannot reach a unanimous verdict. Remember, for all criminal cases, juries have to unanimously agree on the result, whether it is guilty or not guilty. They all have to agree. If they all don't agree, that's a hung jury. And then the last thing that can happen is if something big goes wrong during the trial that sort of taints the jury and messes up the trial, the sides can ask for a mistrial. So a mistrial is saying, nope, there's a mistake that's very bad. We need to start all over. And the judge would evaluate what happened and decide whether or not to declare a mistrial. Now, what happens after a person is found guilty? What is the name of the hearing where they receive their punishment? That is the sentencing hearing. So most times, once a person's convicted, the person goes to jail and the judge selects a time in the future to hold what's called a sentencing hearing. And what the judge is going to do is consider lots of things about the defendant and decide what the sentence should be. Now, in some states, if you commit certain crimes, it's an automatic sentence. So in those cases, you don't need a sentencing hearing because the law has already said, if you do this crime, this is your sentence. New York doesn't really have that. So we have sentencing hearings. So it's going to be another little mini trial type of thing where the judge is going to listen to a whole bunch of different stuff and make a determination what the sentence should be. Now, what are the judge's choices in sentencing? They can send them to jail, incarceration. They can give them jail time and then suspend it and say, well, instead of spending it in jail, we're going to let you serve it in the public. That's probation. You're under supervision. Or sometimes you get sent to jail and you get out early. That's parole. Okay. So what happens if you think that the lower court made a mistake and you want somebody else to look at it to see if they made a mistake? Then you ask for an appeal. So an appeal is when a higher court looks at what happened at the trial and reviews it to see if there are any mistakes. So constitutional mistakes, problems, anything like that. If the higher court thinks that there was a mistake, then they can reverse the decision. But that appeal process is asking the higher court to actually review what happened and see if there were any mistakes. So I have posted a steps in the CJA process practice quiz online. You can take it to review the material and see if you really understand the material. It doesn't count as a grade, so you can take it over and over as many times as you want. Also, I wanted to point out there is no Chapter 12 assignment or discussion this week because we're going to be spending 2 weeks on chapter 12. So I'm going to save the assignment and the discussion for next week. So other than listening to the lecture, making sure you really know all your steps, because you really need to know all the steps. And there's a lot more than what you learned in intro, because we got into a lot more detail. You can take your practice assessment, make sure you're working on Mind Tap, and then start looking over the final project requirements. I posted them, and you can look at them and watch the little video of me explaining what you're going to do. Okay, so that is the end of the steps in the system. We'll continue on with chapter 12 next week. Oh, and I forgot the keyword for this week. So the keyword for this week is discovery. Okay, so discovery will be your key term. So we will continue on with chapter 12 next week, and we'll talk specifically about the prosecution, and we'll talk about the defense. So have a great weekend, and I will see you next week. Bye.